Hello there, it's Project Justice. Welcome. I am Utabo Moran. Nigeria's fight against corruption is still dominating the headlines. The anti-graft agencies, especially the EFCC, has been reinvigorated since the birth of the Buhari administration. But for most critics, its performance ends with a frequent media frenzy of a recovery of looted funds. Apart from a few isolated cases, only a handful of convictions have been secured by the government. So what could be lacking? Is it appropriate investigating tools? Is it diligent prosecution? Or could it be the existence or non-existence of effective laws? Professor Yemi ACJA, a senior advocate of Nigeria, played a key role in the formulation of the Administration of Criminal Justice Act, ACJA 2015. This law was passed by the National Assembly and signed by former President Goodluck Jonathan in May 2015, few days before exiting office. It is a legislation promoters believed will help ease the problem of criminal justice administration, speed up the trial process, and help all actors in the criminal justice system, the victims, the state, and the defendants. But it's almost 2 years since the law was signed. Find out after this news break, while there is little progress in dealing with corruption-related matters, even with the existence of this innovative piece of legislation.
Leader of the indigenous people of Biafra, Nnamdi Kanu, has been granted bail by an Abuja Federal High Court, the third since he ran into trouble with the federal government. The bail is conditioned on 100 million naira with 3 sureties in the same amount, with warning that Kanu should refrain from rallies. The court also held that Kanu must not be seen in a crowd of more than 10 people and should not grant press interviews. Justice Binta Nyako ordered the IPOD leader to deposit his international passport with the court registrar. The court, however, refused bail for 2 other persons charged along with Kanu. Justice Nyako refused to vary an earlier order which sought to protect witnesses in the trial of the IPOD leader. Former governor of Niger State, Babangida Aliyu, has been remanded in prison by a Minna High Court over corruption charges. The former governor was arraigned before the Niger State High Court by the Economic and Financial Crimes Commission, EFCC, over fraud charges to the tune of 3 billion naira. Babangida Aliyu pleaded not guilty to the charges against him. The EFCC has accused the former governor of diverting about 2.2 billion naira from the Niger State government security accounts. He is also said to have allegedly, in collaboration with the 2015 PDP governorship candidate in the state, Umar Nasiko, diverted about 1.09 billion naira, which was 16% of the shares of the state in the North-South Power Company Limited. The Chief Justice of the Federal Capital Territory, Justice Ishaq Bello, has pledged his willingness to work with the Nigerian police to achieve effective administration of justice in Nigeria. Justice Bello gave the assurance during a courtesy visit by the Inspector General of Police, Ibrahim Idris, and his management team. The IGP wants strong collaboration in achieving a crime-free society. Justice Bello is worried that certain factors have posed serious challenges for the justice sector, which include the lack of representation when processes are served on the police. The former Minister of Niger Delta Affairs, Godday Orubebe, has asked the Court of Appeal to nullify the decision of the Code of Conduct Tribunal which convicted him on the failure of his assets declaration. Orubebe raised 3 issues for determination. He asked the court to decide whether his conviction for false declaration of plot 2057 Asokoro District, Abuja, is right in law. He also wants the court to determine whether the tribunal was right in holding that the said property belonged to Orubebe, having shown evidence of transfer of ownership to a third party who is not heard. Orubebe was earlier convicted by the Code of Conduct Tribunal and made to forfeit the property.
And now to our featured interview for this week. Thank you very much, Prof, for granting us this time.
Thank you.
Yes. It's been 2 years since the signing into law of the Administration of Criminal Justice Act, May 2015. How would you evaluate the success and the challenges so far in the implementation of the Act?
The implementation of the Administration of Criminal Justice Act actually started about 1.5 years ago. I would say that we've achieved some significant milestones. You know, there have been some very positive achievements, remarkable achievements, you know. However, much more could have been achieved if there was a deliberate planning by the authorities to give effect to several of the provisions of the Act. You know, so maybe I will score implementation 45%. That's below 50%, yeah, about 45%, yeah.
But by deliberate planning towards implementation, how do you mean by that?
Yeah. When the Act was passed, there should have been a deliberate plan to conduct what I call an assessment of the cost implications. The Act led to the imposition of many additional duties on virtually all sectors, all segments or agencies of the Criminal Justice Administration. Prosecutors were given more tasks, the judges given more tasks, you know, including the so-called day-to-day trial of cases, registrars of court. So investigators all were given additional responsibilities. Yet the resources with which they are expected to carry out their responsibilities remain static. So we should have matched new obligations with additional resources because of the need to give effective implementation to several of the innovative provisions of the Act, which are aimed at addressing long-standing problems in the criminal justice system.
At the time when the focus of the administration is really on the campaign to fight corruption, and the successes for most people is not just perhaps in the recovery of loot, is also in the number of convictions you can be able to secure in court. One of the key aspects to it would be effective investigation, because going by what this Act provides for, everything has to be done diligently before you approach the court for trial of a case, which has to run on a day-to-day basis. What is expected to have been done in terms of empowering law enforcement institutions in the areas of investigation?
We need first and foremost to identify the additional tasks that law enforcement institutions have to perform. I'll give an illustration with respect to bringing witnesses to court. In order to be able to give effect to day-to-day trial or the stipulated maximum of 14 days interval between adjournment of cases in criminal proceedings, that means before arraignment, the prosecution must ensure that the witnesses are ready. Before you arraign a suspect to court, you need to ensure that your witnesses are ready, your documents are ready. You know, that's why, you know, the FCT, you know, I mean the judiciary in the FCT, you know, is taking a step in the right direction by putting in place what we call practice directions, case management guidelines. You know, all of these things are necessary before the benefits of this law can be fully realized.
What is similar in the trial of criminal cases in line with the Administration of Criminal Justice Act? So what we find obtainable in election petition matters where timelines are given, exactly, where materials and documents are front-loaded ahead of time before trial proper commences.
Absolutely. The ACJA Act provides for front-loading. When an information is filed, there are certain documents, proofs of evidence, statements of witnesses, reports, and, you know, other documents that you're going to rely upon. All of these things must be front-loaded. You know, so timelines are also provided. Attorney General to issue legal advice in 14 days, courts to commence trial within 15 days of filing, chief judge to assign cases within a certain number of days. You know, all of these timelines require planning before the agencies can effectively comply with them. You know, so we didn't have sufficient capacity building, we didn't have sufficient resourcing of the institutions. For example, investigators of cases, police investigators, prosecutors have to use their own funding, their own money, their own resources to fund service of witnesses. That's very embarrassing. Prosecutors are not assisted with transportation to court. Investigators have to go after complainants, looking for people to come to court, spending their own money. This government ought to prioritize all of this support for administration of criminal justice so that the objective of government of prioritizing the anti-corruption fight can be given practical effect. If on the one hand we say we want to fight corruption, we want to prosecute more cases and all of that, and the people who are investigating these cases, the judges who are trying these cases, the witnesses and all of that, all of whom must be present for the case to go on. If nothing is being done at that end, then the objective of better prosecution may not be achieved.
What would you highlight, Prof, as the number one reason for the current delays we are having at the moment? Because people, apart from lack of proper investigation, which you've mentioned, a lot of people have also mentioned lack of effective prosecution, because whatever the investigator does is a prosecutor that would now marshal those things out before the court to secure conviction where necessary.
Yes. For me, the most important factor, and I think contributes to the delays that we have, is lack of synergy, effective coordination amongst the various agencies. For example, before this act can be effectively operational, we need courts that concentrate only on criminal trials. I'm not talking about specialized courts, special courts. Special courts reminds us of military tribunals. That's not what they are talking about. We are talking about special divisions of courts that deal with only criminal cases, particularly anti-corruption cases, economic crimes. The judges who handle these cases should concentrate only on those cases. And then those courts are equipped to receive evidence electronically. So they don't need to take notes in longhand, which has been provided for in the Administration of Criminal Justice Act. These courts should also have what we call witness support service. Witness support service. Then there should also be a crack team of investigators, maybe drawn from all the police, EFCC, ICPC, all the prosecuting agencies. So that when we have some of these very important, highly prized cases that mean so much to the country. Of course, all cases are important, but we can start with these high-profile cases in which several billions have been removed from the treasury. So if we are not able to complete these cases because we did not put in place mechanisms that the law requires, then you do not blame the courts alone. You do not place the blames on the court. What we need to do is look back. Where have we failed? Where is the coordination system in place? Witness protection, is it in place? Prosecution service, are they in place? Are they well equipped? Are they well resourced to deliver? Service of process. So unless we address these issues of synergy, issues of coordination, we'll continue to have disappointing outcomes.
Some persons also have or feel disappointment on the part of the judiciary as well. But so far, how has the judiciary, especially the court, helped in further strengthening the administration of criminal justice, particularly Section 396, that supports day-to-day trial, that prohibits unnecessary adjournment based on interlocutory applications that goes to the appellate court, suspend trial, like we've seen in several high-profile criminal cases or corruption-related cases that have stretched for over 7-8 years. How has the court been able to help, in the implementation of this section in particular?
First and foremost, we give kudos to the Supreme Court. When it declared that interlocutory applications will no longer be acceptable as a means of delaying trials. That was a major victory. So that's a laudable input by the judiciary. So the Supreme Court has set the guideline that you do not postpone cases simply because people have raised some objections. The law says those objections should be taken along with the substantive issues and decisions pronounced together. That is fully legal. It is done in human rights cases. It is done in election petition cases. So it is not new. So the Supreme Court has rightly decided that that provision should be upheld. Secondly, the court has also given room for liberal admissibility of electronically generated evidence. Given effect to the provision of the Evidence Act, the court has been very liberal in admitting email evidence, electronically generated evidence, statements of witnesses taken electronically. Once you lay the proper foundation, the courts are willing to admit it. In fact, the court has been very liberal. They have opened the door. The principal rule now that governs admissibility of evidence in our court is relevancy. Once it's relevant, it's admissible. Even if there are some technical issues, of course, those ones will go to weight. And that's why the courts are even liberal with respect to trial within trial. They no longer insist that you must conduct trial within trial. What you need is put all the evidence before the court with respect to voluntariness of confessional statement. When the defense is presenting their defense, they bring in evidence to show that the statement was not voluntary. You do not have to set aside the main trial and start to conduct trial within trial. So there have been a lot of positive declarations and decisions from the courts, despite the fact that the courts, but there are still challenges with respect to postponement of cases. Yes. We still have cases being adjourned for 30 days. We still have cases being adjourned for 2 months. We do not yet have effective planning of cases. But you cannot blame that on the courts alone. If the prosecution does not show readiness, how can the court say, come and try your case within 4 or 5 days?
Did the ACJA 2015 provide remedies to such instances where, for instance, where there is lack of diligent prosecution?
There are provisions with respect to wasted costs. The court is allowed to award costs to discourage frivolous adjournments as a result of non-diligent prosecution of cases. But the courts have been very reluctant in awarding costs.
Prof, I ask this question because there are people who feel some of the corruption-related cases that go to court do not necessarily have any business going to court.
Yes.
And that some persons perhaps are being prosecuted based on malice or whatever they think of. That's why I'm asking, where such cases go to court and case can move forward as it's supposed to, is there any remedy for the defendant before the court who feels ordinarily, I shouldn't be before this court?
There are several remedies. For example, there's provision for no case submission. After the prosecution has gone through the case, there's provision for no case submission. There's also provision for a judge who looks at charges that are patently bad. They can throw them out preliminarily, with or without objection from application from the defense. However, the judges have even been very liberal. They listen to everybody because they do not want to be accused of siding with the so-called corrupt defendants. So I have cases in court that I believe ought to have been thrown out because the evidence is not before the court. You have adjourned the cases several times, and yet the courts continue to keep them because the courts are vilified. They are accused of not wanting to fight corruption. So I think, that there's need to strengthen all sectors. There's need to build capacity, create awareness, and then there's need, after the awareness has been built, capacity has been built, I think the judges will now be in a place to say, look, prosecutor, you have not done your case well. Case thrown out.
Which goes back to your argument of providing enough support systems for investigators and prosecutors as well. Prof, some other sections of this Administration of Criminal Justice Act, lawyers, members of the legal communities, academics like you and law experts have said is controversial. Some have said he's even in conflict with the Constitution, provision of the Constitution, especially Chapter 35 of the Constitution. I talk about Section 2931 of the ACJA, which vests magistrates' court with the power to issue remand orders for detention of suspects pending arraignment before a court of competent jurisdiction.
Remand proceedings.
Remand
proceedings is absolutely constitutional and legal. The Constitution permits that while a case is being investigated, suspects can be kept on remand. In the past, it used to be called holding charges. Under holding charges, defendants can be kept for 6 months, for 1 year, for 2 years, endlessly, without. But under the ACJA Act, under the ACJA Act, a provision has been made in Section 296 to replace the holding charge, and there's no legal system that has capacity to try every suspect right on the spot because you need time for investigation. But what we have done under the ACJA Act is that the police cannot keep people beyond the 24 hours or 48 hours permitted by the Constitution. So they have to get to court, get a remand order. And 15 days after the first remand order, they must come forth with evidence with which to institute the case at the appropriate court. They must file the charge at the appropriate court. If they don't, the magistrate is automatically bound by law to recall the case and ask the police to show cause. If they are not able to show cause, why the suspect should continue in detention, release the suspect.
But perhaps what their argument has been is that if the Constitution says anybody that has been arrested for any offense must be charged before a court of competent jurisdiction within a reasonable period of time of 24 or 48 hours, charged to court, not going to court to get a remand order to keep the person, which is what the ACJA is talking about.
Yes. You can only detain persons for what is called probable cause. Arrest must be for probable cause. And there must be affidavit evidence on the part of the prosecutor that this is what we have found. We are investigating this case, and we need time to be able to complete our investigation. The magistrate is not bound to a grant remand order when there is no affidavit evidence showing probable cause. Look, there must be a balance between human rights and security interests of the state. If the state loses capacity to maintain law and order, to hold wrongdoing to account, everybody is endangered. So there must be a balance. And that balance has been struck by Section 296, which says that when there's proof, affidavit evidence before the court, and there's probable cause, then if arraignment cannot be done, if the cases cannot be brought, of course, in the FCT, the CJA has insisted that rather than going to magistrate court to obtain remand orders and then delaying the filing of or arraignment, come straight to the High Court. We are willing to give you fantastic, because he says, and his argument is that there are courts within 40 kilometers radius. Yes. So anti-corruption agencies may as well, but again, it's not as smooth as that. It is faster to get remand orders from magistrate courts, unless the CJA, and he has the authority to do that, puts in place machinery which will enable anti-corruption agencies and other people who need rapid action to be able to get remand orders before filing
How do you deal with the possibilities of, abuse of the process? Because you talked about the case of the FCT CJ Justice Ishaq Bello.
Yes.
He issued a directive that magistrates should be a lot more circumspect in issuing those remand orders, because in his opinion, perhaps it was abused. And, some critics came after him that such directive is ex cathedra. He is not within his powers to do such. But those possibilities of abuse have been known to exist in our system. Yes. So is there no possibility of reviewing that section to perhaps whittle down the powers of the magistrate court, or which prosecutors would always want to exploit to get remand orders to put whoever they want to put in detention?
Lagos State placed the interval of remand to be 30 days. That is, remand order can last for 30 days in the first instance in Lagos State. But at the federal level, the Act places 15 days as the maximum duration of a first remand order, 15 days. Now, a review of the Section 296 may say that cases should be brought before courts that have jurisdiction to try the offenses immediately. That would be a very positive review. But that has not happened. That has not happened. Meanwhile, what we have is what the Act says for now. Look, abuse is not necessarily inevitable. Why? Because a defense counsel who is diligent, once your client is taken to custody and given 15 days, all you need to do is work with the prosecutors. Work with the prosecutors so that arraignment can happen as quickly as possible. The 15 days, it does not mean that a suspect who is held in custody must necessarily spend 15 days before arraignment can happen. If there's cooperation in the investigation, the cases can move pretty fast. So the ball falls back to the defense counsel. The moment your client is held, you can start your application for bail immediately. The law provides for that. And the ACJA Act is very liberal on bail. And the reason the courts are very reluctant to grant bail sometimes is that we are not giving effect to the provision of the ACJA Act on documentation of witnesses, which must start from the police station. Once you have the information you need on witnesses, under the Evidence Administration of Criminal Justice Act, once the minimum information is collected, there's no reason why any defendant should be kept in detention without trial. Because the objective of the ACJA Act is that defendants should not be detained without trial. But when it becomes inevitable, that's why Section 296 comes into place. Yes. But the Act is in favor of bail. It's in favor of liberal grant of bail. But there must be adequate profiling, adequate information, including getting the BVN, fingerprints, photographs, so that the witness, so that the defendant will be available when trial time comes. Okay. The Court of Appeal has said that it is consistent. There's a recent decision from the Court of Appeal, Hakim and FRN. Laudable decision. That's another way in which judiciary has been very promotive of the ACJA Act, because it has strengthened their ability to do their work. Judges feel frustrated when they cannot conclude trial of cases because of interposing interlocutory applications. You stay proceedings, even in cases that have merit. You just file some unmeritorious applications. You hang the case for several years. You go to the Court of Appeal, you go to the Supreme Court, only for the case to be sent back for retrial. Where are the witnesses when you go back for retrial? They're nowhere to be found. So judges are very supportive of the Administration of Criminal Justice Act. And this administration also needs to also put in place more legislation. Process of Crime Act. There's a whistleblower policy, but there's no Whistleblowers Act to protect the whistleblowers.
It's currently before the National Assembly, though.
Precisely. All of this have to be put in place so that we can have a more robust regime. And more importantly, the need for preventive laws. It is better to prevent the loss of government money than to start fighting people after the money has been taken.
What is the role of the Nigerian Financial Intelligence Unit?
That's part of it. That's part of it. The banks, cashless systems, there are a couple of things that can be done by government. And everything is working towards that. Tax implications, where some people have gone out, you find out what tax have they paid to justify the amount of expenses that they have, the amount of resources that they control. When all of these things are in place, you find that corruption will reduce drastically.
What is your opinion, Prof? Because when the acting chairman of the EFCC was before the Senate for his confirmation hearing, Botch confirmation hearing, there was an issue of whether the NFIU should be embedded in just one office, in this case, the office of the EFCC.
NFIU should not be embedded in one institution. NFIU should be an independent institution that provides information to all the agencies. That's how it is in other jurisdictions. NFIU should not be embedded in any single institution. It should be an institution that helps all the agencies.
Now, as laudable as the provisions of the ACJA is, only about the Federal Capital Territory and the federal courts are within the jurisdiction for its implementation. Yes. What happens? We have 36 states of the Federation.
ACJA has nationwide application to the police. We have police all over the country. Those provisions relating to the police are applicable all over the country, but there's a limit. Going to courts, state laws apply. Yes. So that is why it is recommended that as all the states should key into the ACJA principle. And happily, 7 states have passed the ACJA. They have local variations of the ACJA. And I know more than 7 states are in the process of passing it. That has been a very rapid movement. I'm sure within maybe another year or two, most states of the Federation will have keyed into the reform.
This is no less exhaustive, but I'm sure we'll have time to talk to you more on this.
Yes, thank you very much.
Professor ACJA, George, thank you so much.
Thank you, Utibe Omore. You're doing a good job.
Thank you.
More of it, please.
Well, that's the show this week. Join us again next week. On behalf of the entire production crew, I am Utibe Omore.